Imagine this, a high-stakes courtroom, weeks full of grueling testimony, and suddenly, the entire trial is put on hold because of a major slip-up by the prosecution. But was it really a slip-up, or was there a hidden motive behind the prosecution's play? Now, in today's video, we're going to dig deep into what really happened. Was this a calculated play from the state, or was this just another honest mistake? Was this an actual play from the state and able for them to delay the trial, or was the state actually pushing P for the bigger picture, with it being election time? And why was the judge willing to fix the state's errors with such ease? And let's keep it real. We all know that when it comes to the DA's office, they're not helping any of the defendants when it comes to these pleas. But before we dig deep, man, y'all make sure y'all tap that notification bell, subscribe to the channel if you're not subscribed, and definitely tap that like button. Whether you're a fan of the case, the state of Young Thug and YSL, tap that like button. Y'all know the vibe. Y'all ready? Let's dig.
A judge canceled court for the day in the ongoing YSL racketeering trial as she considers declaring a mistrial. This comes after another misstep in court yesterday by prosecutors. I
was going to address with him because it wasn't I did not realize it was an issue. Mr. Rubin found out for me that Slat Quay is not either of these two Quays.
Okay, but this isn't Slat Quay. This is just Quay.
Right.
I know. So why doesn't everybody, well, they don't know how it's spelled. They only heard it. Why doesn't everybody just enter into some sort of a stipulation that the free Quay or the reference to Quay just now isn't either of these people?
Now, ask yourself, how many more times can this judge actually cover the state? How many more times can the actual state participate with the state? Now, we're all watching this case, and there's a lot of rumors and allegations going around about pleas. But one thing that we do know is that the state definitely dropped the ball. So ask yourself this, why is it that the judge is so adamant about fixing the state's problems when they've never done the same for the defense? Let's dig.
Okay, so.
Your Honor, the state can enter stipulation that we weren't referencing it. We as the state of Georgia.
Okay, that is not a reference to, if you would prefer that.
I don't know what the poster is.
I don't honestly really care what the poster was referencing. What I'm trying to do is fix your sloppiness so that everybody won't have wasted, 10, 12 months of their lives in this trial.
About the roller coaster of problems the trial has seen, from illnesses to attorneys and jurors being arrested, defendants stabbed, and even a judge being removed.
So let's dig. So this hashtag free Quay, ask yourself, was this just an honest mistake from the state, or was it actually another calculated maneuver that was orchestrated by the state? In my personal opinion, I feel like the state actually set this up. The whole play, you knew about the information, the judge is trying to correct your errors. Never hear them say that they're trying to correct the defense's errors. Montunk didn't get his errors corrected, his attorney didn't get his errors corrected, but you're willing to correct the errors made by the state. Straight sloppiness and straight biasness. Now, in my personal opinion, I feel like all of this was actually just a play, because if it is true that the plea was actually taken by the defendant Quay, why did this not happen before when it was asked from the defense and denied by the state? Let's dig.
That the current cross-examination suggesting that counsel is putting facts before the jury that don't have any foundation, or to confuse them, or through an investigator that aren't exactly facts that are and can be established as prosecutorial misconduct. I'd refer to specifically, for example, with those examples, with regard to confusing the jury, with regard to someone's investigator, United States versus Rios, R-I-O-S, 611 Fed 2nd, 1335, at 1342. That's a 10th Circuit case from 1979. I am not talking about the quantum of proof. I am for the spillover effect. But the nature of the attacks on co-counsel and lack of any connection of any of this evidence for the last, how many days has Mr. Bean been on the stand? How many trial days? None of which has any specific connection to Mr. Nichols whatsoever. So based upon what I believe is now personal attacks between lawyers and nothing to do with Mr. Nichols, the spillover effect has now reached a point where I believe we are entitled to a severance and or my favorite and your favorite, the 105 instruction.
Yes, sir.
Thank you.
Okay, Ms. Hilton.
It will be me, Your Honor, that is being presented through this witness is one of the overt acts listed in the indictment. It is a part of count 1 with which Mr. Harvey's client is charged in this indictment. I'm not certain when he speaks as to personal matters regarding attorneys. I'm not certain what it is that he refers to when he speaks of that, but there's nothing that I have asked that you do not have a good faith basis for asking. I have not made any personal attacks or innuendo regarding anyone. I've simply placed questions upon this witness for which I have a good faith basis for asking. And so I would ask that the court, based on the fact that this information is one of the overt acts that are alleged as a part of count 1, and based on the fact that Mr. Nichols is charged in count 1, we would ask that the court deny Mr. Harvey's motion for an instruction and deny his motion for a severance.
All right. Mr. Harvey, I'm going to use to include the case you just cited, as well as the other cases that have been offered for this particular proposition in the past. I'm going to deny your motion for severance at this point in time, and I'll deny your 105 request for an instruction. I'll give you a continuing objection, okay? All right, thank you, sir.
Now, the big question is, if these defendants actually selected to take these pleas, how would it actually impact the trial and the other defendants that chose to not take the pleas? Would the state make these defendants testify and be forced to testify against the ones who decided to not take the pleas from the state? Or was this just a bigger play on the case? Because keep in mind, in my opinion, the defense is definitely winning this case. But if you can get some of these defense attorneys and these defendants severed from the case, is that just a bigger play from the state? So to dig even deeper, ask yourself this: was this just a strategic delay from the state or just an honest mistake? And remember, the state does have the burden of proof. So with all the direct pressure coming down from the state, what did the judge mean when she said she was trying to fix the mistake?
Schiffer says District Attorney Willis is for sure feeling the pressure, as she has assured voters she will prosecute. Fox 5 has learned several defense attorneys are working to negotiate plea deals in the case.
Now, before I give my personal opinion on the defendants and their pleas, was this politically motivated just to get the voters of Fulton County up out their seats? Ironically, the trial stops the same as election week. Let's dig.
Charged with count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, which carries a sentence of 5 to 20 years. You were also charged with count 49 in this indictment, which is murder, which carries a sentence of life. You were charged with 2 counts of participation in criminal street gang activity, which was counts 50 and 51, which each carried a sentence of 5 to 20 years. You were initially charged with counts 53 and 65, possession of a firearm by a convicted felon under Code Section 16-11-133, which each carry a sentence of 15 years consecutive to count 1. And then you were also charged with count 54, which is possession of a firearm during the commission of a felony, which carried a sentence of 5 years consecutive to count 1. Do you understand that is what you were initially charged with?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had an opportunity to go over and review the waiver of rights form with your attorney?
Yes.
And I'm going to hand this to your attorney. Did you sign this along with your attorney?
Yes.
Have you had enough time to speak with your attorney, Mr. Bruce Harvey, about all the facts and circumstances known to you regarding the charge in this indictment?
Yes.
Do you need any more time to discuss this man with your attorney?
No.
Are you satisfied with his counsel and representation?
Yes.
Do you understand this is a negotiated plea of guilty, which means that the state will recommend to the court as to count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, a sentence of 20 years to serve 7 years in custody, balanced on probation.
Yes.
Do you understand that as a part of the negotiated agreement, the state will null, or dismiss count 49, which is the murder count, count 50, 51, which are the gang activity counts, count 53, possession of a firearm by a convicted felon, count 54, possession of a firearm during the commission of a felony, and count 65, possession of a firearm by a convicted felon. Do you understand that is the negotiated agreement?
Yes.
Do you understand that the court does not have to accept that recommendation?
Yes.
And the court can sentence you to the maximum on each charge and can run those charges consecutively or one after the other?
Yes.
Well, there's only one charge that
so
a guilty plea is
I
being
listen-
entered into, so
Under my breath to that.
there's no other sentence to run anything consecutively with regard to this plea. You understand that?
Yes.
Okay.
Now, before we even crack down and make a joke on how the prosecution still fumbling the ball with their own negotiated pleas, man, let's actually talk about the plea. Now, this is an actual huge W when it comes to this defendant specifically because, man, he was facing life and you just got it reduced down to 7 years plus time served. Now, the 13 years on probation, I always say that's a definite double-edged sword. 7 years definitely beats life. The other thing is they actually said that he also had no negotiated special conditions. What that means, to those who don't understand, that means he will not have to take the stand and testify against any of the other defendants that are right here on this trial, which is interesting because how could this actually be beneficial to the entire case overall? Let's dig.
With respect to indictment 22 SC 183572, how do you plead to count 1, conspiracy to violate the Racketeer, Influence, and Corrupt Organizations Act?
Guilty.
Is this guilty plea freely and voluntarily given with a full knowledge of the charge against you?
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have 4 years from today's date to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
And that can challenge anything about the constitutionality of the plea. It's not limited to voluntariness, understand?
Yes.
And Your Honor, if this case were to
Hang on just a second. You also have, so 4 years for that to file a direct appeal. You have 30 days from the date of the sentencing, which is going to be today. And you have until the end of this term of court to file a motion seeking to withdraw your guilty plea. That doesn't mean anything like that would be granted. You would have to establish facts that would warrant that. But that's just the time period is until the end of this term of court. Do you understand those as well?
Yes.
All right.
Now here is where the state just makes my blood boil when they handle defendants, witness, or even just people in general. Now it's interesting, as you see, they're just rolling along with this plea that the defendant has clearly accepted. But ask yourself this, why is it that the judge has to continue to stop the case to make sure that she fills in the state's mistakes? Why not thoroughly explain this man's rights as he's going through this plea as you taking away his freedom? Is the state actually in their feelings because he just beat an M charge and got 7 years, 13 years on probation, plus time served? Psh, big W. But even worse, ask yourself this. Why is the state portraying like his plea can actually be used against any of the other defendants in this trial? Which it can't. No special conditions that they just went over right here on the record says that his actual plea can be used against any of the other defendants. So he's not admitting conspiracy, not admitting gang, not admitting Rico, not admitting any of that. This is a plea that's specifically tied to the defendant. So ask yourself this, why did it take the judge to step in and make sure that everybody had a clear vision? Let's dig.
You understand that?
Yes.
All right. And you do want to enter this guilty plea?
Yes.
All right. And Mr. Harvey, have you advised Mr. Nichols of the alternatives if he does not ultimately go through with this guilty plea and the potential benefits and drawbacks of all of the other options?
Yes,
All right.
very thoroughly, Judge.
All right. All right, Mr. Harvey, is there anything that the defense wants to add to the record?
Judge, other than the statement with regard to the underlying factual basis, I would point out for the court that when Mr. Nichols filled out his form, it says 29 plus. He is a birthday boy in a couple of days and he will be 30. And at 30 years of age, he has a wife, he has got a 13-year-old daughter, he's got a 10-year-old daughter, and an 8-year-old son. His wife and sister, I believe, are here in the courtroom to support him. He, Mr. Nichols, was born and raised in Atlanta, and you know, we're at this point, before I have even given my opening statement in this case.
Yes, sir.
I do want the court to know that Mr. Nichols' mother died in prison. His father was shot by the Atlanta police when he was 4 years old. And he was raised by friends and family in the Atlanta area. So he has come to this point in his life from a very humble beginning, and he has sought the support of friends in this courtroom and others in this courtroom. He is an intelligent young man who I believe has a future. Every day we do a word of the day. We put a new word into a sentence. And I think this is in his best interest. I know that there is, and I know this plea is negotiated, but it's a long downside from 7 to 20. So the courts will have jurisdiction over him for a period of time. So I ask the court, given who this young man is, and given our categorical denial of some of the factual basis, to accept the plea and sentence Mr. Nichols accordingly.
Mr. Nichols, is there anything that you want to say?
No, ma'am.
All right. Whether the defendant, and in this case, the defendant has acknowledged guilt and is accepting responsibility for his guilt of the Rico count, and whether accepting the plea will aid in avoiding further delays, not just with regard to this case, but with regard to the entirety of our system here in Fulton County. And this plea does go towards doing all of those things. I am going to accept the plea as negotiated and sentence in accord with the negotiated recommendation. As I said before, find there to be a factual basis for count 1 of the plea. I find the plea to have been freely, knowingly, intelligently, and voluntarily entered into by Mr. Nichols with an understanding of the consequences of doing that. And the sentence on count 1 is the sentence that has been negotiated of 20 years to serve 7, with the balance of those years to be served on probation. And that, I don't know if there are any special conditions attached to this that y'all have talked about at all.
There are no negotiated special conditions in those, so there are none as far as I'm concerned.
All right. No. Okay. So with regard to the time that you are on probation, you need to stay out of all kinds of criminal trouble. Make this a birthday present to yourself and to your children and to your wife and family, that you will leave from here today and leave whatever you used to do behind you, and take the next few years. You know, you're going to have some years that are still to be served on this. You'll have credit for the time you've already served, but you're still going to be facing some incarceration time. But after that, you are going to be out, and you, I believe, Mr. Harvey is correct, can be a productive member of society, and this is an opportunity for you to do that, and for you to put your past behind you, the bad parts of it, and continue and make your children proud of you, and set a good example for them, an example that I guess unfortunately you were not lucky enough to have throughout the entirety of your childhood with your parents. I'm sorry about that, but you can be the kind of parent that you ought to be to your children. So I am going to impose that sentence, and I am going to wish you luck and good fortune as you go forth from here. So I think that unless there's anything else from either party, that will conclude these proceedings, and y'all can go ahead and take him into custody. Thank you.
Thank you, Judge.
So let's dig. Man, this defendant just got off sweet. He just beat a whole M for the state. Now on the books, the state still got a W because they got the plea. But at the same time, the W for this man and his family is definitely bigger than what the state could actually do on their side. This man just beat a whole M charge, 20 years to life. You just got to reduce down to 7. Time served, half of the time served. 13 years probation. This man will be out. Georgia, a 2-for-1 state. He'll be home in another year, 2 years. So he just really just got off sweet. Plus no actual conditions, special conditions for him to have to take the stand and testify. So his plea can't even be used against the other defendants in the trial. In my personal opinion, I say he came off sweet. Now, y'all jump in the comments, let me know what y'all think. Was he wrong for taking a plea, or did he actually do the right thing? Did the state actually really want to hand out this deal? And ask yourself this, will Young Thug, Shannon, and the other defendants actually come out like this as well? Man, until next time, remember, the greater the weight, the greater the bag. The life you save might be your very own. Until next time, y'all jump in the comments. If you're not subscribed to the channel, subscribe to the channel. Turn that notification bell on. Hit the like button. Whether you're a fan of the state, Young Thug, or the case, hit that like button. Until next time, remember, the life you save might be your very own. As always, I'm your host, Jay. Gone.